Hi, this is Mary Guzman. It's been a long time since we recorded an episode of Cover Your Assets, our podcast where we talk all things trade secrets. And today I'm absolutely thrilled and excited to have with me Ayaz Hameed, who is a brilliant strategist around intellectual property assets and with venture capital and all things innovation assets. I'm going to let him introduce himself and talk a little bit about his company, and then we'll get into the topic of our conversation today, which is really about overlooking or not overlooking the value of intellectual property assets and how big of a difference that can make in longevity of a company and or its valuation. So with that, Ayaz, thank you for joining me today.
Thank you, Mary. I'm super excited. I will say, you should also say I'm an aspiring podcaster like you, because I've never done one, but I'm a huge consumer of podcasts, and this is my first appearance on one, so I'm really thrilled to be here with you.
Oh, it's exciting. Very cool. Um,
Um, Go ahead.
yeah, I was just going to say, tell us a little bit about Prestiza and what you guys are doing.
Yeah, so Prestiza, so it's been around for a while. There's really two arms of the business, and I think they're both relevant to the conversation today. One is a real estate development arm in Boston, where we build single-family, multi-family housing, and that's going to be a very relevant metaphor to the trade secret insurance stuff that we're going to talk about. And then on the other side, think of Prestige as a growth firm, but it's not really a firm. It's a consortium of investors and operators, and we're slightly different than your traditional financial services or private equity firm in a few ways. One is table stakes. We bring growth capital to companies, but we also bring operational expertise with fractional C-level services across all business functions to help companies solve their challenges. So I should just take a step back and mention that unlike most financial services firms who are either looking to buy companies or not, we typically take an approach where we try to integrate ourselves inside the operation of a company, try to add value, build trust, and then when and if the owners or the management teams are ready to sell the company, we're there as a natural exit partner. So the fractional C-level services are very relevant on that side. The third thing that's very, I think, unique about it is that we don't do trial and error. We have battle-tested frameworks that we help to solve real problems quickly. So one of the very relevant ones is about creating strategic IP assets, which can help increase the value of a company by 3 to 5x within 90 days, without spending a lot of times any money on product development. So that's a very unique asset of ours. And then finally, we don't just buy technology companies. We actually have the technology muscle in-house where we can deploy technology solutions as needed by businesses that we partner with. So that's kind of at a high level of what Prestiza does.
Wow, that's awesome. And I love the fact that you just kind of skated right over this statistic that you threw out that my jaw dropped when you said it, especially when we were preparing for this discussion, which is that just by helping harvest and identify and put a value on essentially the intellectual property assets of a company, you can increase its valuation by 3 to 5x. Did you say in 90 days?
Within
And I
90
know that,
days.
and I know that you wrote, you wrote an awesome article about getting 10x, getting a 10x multiple for your business. And I really enjoyed reading that because that's something, just so you know, we get asked every single day when we're talking to brokers and other organizations about why doing what we're doing, which is putting a value on intellectual property assets, trade secrets specifically, which traditionally companies have not done, looking at the security around them and then putting an insurance wrapper, why that increases the valuation of the company as opposed to just protects the downside risk. And we're always looking for real evidence of that. So if you can talk about that a little bit more, you might just make me $1 zillion.
Yeah, I wish. So a pitch book really helped us out in that regard, both you and I, right? I'll give you a funny story. When I first started my journey as an IP lawyer, I never worked at a law firm. I was at a company called Pegasystems for about 15 years, and I did a variety of different roles. And I went to law school at night. So the CEO hired me to run the IP strategy for the company directly out of law school, and which was an unusual position to be in, but I was thrilled to be in that because I guess unlike most lawyers who were doing IP work for the company, because I had been in the company for so long, I knew the business really well, right? I knew the product, I helped build it, I knew the go-to-market strategy, I knew the sales motions, right? So when I took over the IP strategy and looked at the patents that were inside the company, I couldn't for the life of me figure out how they tied to the business and how they were helping the business, right? And this is the days of the heyday of patent trolls, right? Like in early 2000s when everybody was getting sued left and right. BlackBerry lost like a $612 million judgment to a patent troll. So the reason I got hired and in many ways was tasked to do an IP strategy presentation right out of law school was because we had a board member who came and joined the company and said, "I can't believe you don't have an IP strategy." So the CEO said, "Hey, go figure this out." And me coming out of law school, I'm like, "All right, this should be easy. I'll just figure out the IP strategy for this $650 million company within the next 30 days."
Easy
But
peasy.
easy peasy, right? And this is before Chat GPT, so I'm like, okay, let me go do some research. But to your point about the valuation, a lot of times I think the disconnect ends up being that what are the patents or the IP actually doing for the business? So in that case, in the context of that business, it wasn't doing much, right? But when you look at a lot of technology companies today and you look at a lot of technology or non-technology companies, there's always something unique about that company, which is why they're successful, right? And it took PitchBook to look at about 14,000 companies and sort of look at the data of these companies about how they were being funded, at what valuation, how many of them are going public, and how many of them are exiting at what price. And so the data clearly showed that the companies that had valuable IP assets were getting funded more often, were getting funded at a higher valuation, were going more likely uh, to have an exit. So now, is that a causation or a correlation? Hard to say, right? But I'll just give you a very interesting thing that I pointed out in my article is that there's two aspects of the value of a business, right? There's the financials of the business. Are you generating cash flow? Are you profitable? The second is the intangible assets. So if you look at, as an example, Facebook acquiring WhatsApp for $19 billion or $16 billion, whatever it was, they had almost zero revenue. So why would a strategic buyer buy a company for $19 billion that has no money? It's the intangible assets, right? It's the network. It's the encryption technology. It's the cross-selling opportunity and the synergy. So when it comes to the value of the business, you have to look at it and say, well, it lies in the eyes of the beholder. Like a financial services firm is not going to value the same company uh, the same way that a strategic buyer would. But what is without a doubt sort of established is that unless you have something unique about your business, you're probably not going to be successful from a financial standpoint. And if there is something unique about a business, you better protect it because otherwise somebody else is going to protect it, steal it, and recreate that value. Um, so yeah, so that's where I think the valuation piece comes in.
Yeah. Well, and one of the other things that you mentioned, I think, in a different article, because, now, and we'll talk about rippling versus deal, because I think that's a good example of something where what we're doing could have made a really big difference on either side of the V of that litigation. But in a different article, you talked a lot about companies who've actually lost their trade secrets and their competitive advantage and what ultimately has happened to them. So not only are we talking about increasing the valuation by multiples of 5x potentially or 10x, but if you don't do something, there's the really negative ramification of potentially bankruptcy even.
Yeah, and this is the one that's I'm really surprised that people don't. I am surprised and I'm not surprised, and let me explain what I mean by that. So I was recently actually listening to a podcast about this, and there was a quote by James Comey, the FBI, former FBI director, who said there's two kinds of companies that are out there: the ones that have been hacked by the Chinese, and the other ones that don't know they've been hacked by the Chinese. So if you want to think of the example of the latter, and I mentioned this in my article before I even knew about this quote, was Nortel Networks, right? $250 billion telecom giant, and completely wiped out because they didn't even know that they were being hacked for years by the Chinese and their competitors, right? All their roadmaps and sales strategies, and Huawei and these other Chinese firms just ate their lunch, right? So these threats of trade secret theft are extremely real, right? So um, I mentioned the metaphor now that we talked about earlier about the property development, right? So if you think about when I build a $10 million building and I go to a bank and I say I want to take a loan out for the construction thing, the first thing they ask me is, do you have any insurance policy, a builder's risk policy, right? If I'm an investor who's investing $10 million into a building, I better make sure that a wind system is not going to come in and knock the building out 80% way through construction without me having some sort of recourse around it, right? And so this trade secret theft being as prevalent as it is, and now with the NDAs not being enforceable, it's only a matter of time. And then Rippling and Deal, we'll talk about this in a bit, but it's only a matter of time that somebody will hack into your system and steal your data or whatever is valuable about your company. Your employee is going to walk out with 14,000 documents that I mentioned in my article, and it's going to go to a competitor and do it. So not only is it almost irresponsible to not sort of physically protect those assets, but to plan for the inevitable thing that when it happens, do I have insurance around that or not, right? And that's, I think as a market, we have to do a better job of educating people on that point.
Yes, we are killing ourselves trying to educate people on that point.
Yeah.
And actually really want to have some conversations with lenders about that, private debt in particular, because I think it should be a required insurance, as you suggested, for, if you're looking to loan money or even invest in a company. If you're not lending but investing, what kind of protections do they have around their IP? Do you even have evidence that it's owned by the company, number one? And number two, that you have proper protections and insurance around it. That brings to mind two specific claims that have been relevant in very recent memory. One of them was about in the e-cigarette space, where Juul successfully prevented a competitor of theirs, where one company had just bought another for the purpose of competing against Juul in the United States for the e-cigarette technology that they had. Ultimately, after the deal closed, the ITC came in, made a judgment, full stop, unappealable final ruling, that the company, their Juul's competitor, whose name is escaping me at the moment, but anyway, is no longer allowed or is not allowed to import any devices into the United States, period. So now one company bought another to compete against Juul in the United States, and now they can't even import their devices into the US. Clearly, they did not do proper due diligence on the ownership of the IP assets in that particular case.
Yep.
In the Rippling case, which Rippling versus Deal has been all in the media, where Deal has allegedly misappropriated hundreds of trade secrets, using a plant that was inside Rippling's organization, a person who was sitting in their Ireland subsidiary and HR, accessing files from their internal Slack channel. I've posted a couple of videos and written some things about this on LinkedIn, because as much as I think that Deal was really shady in what they did, and that hopefully there'll be criminal ramifications against them for under the Electronic Espionage Act and RICO and other things. I'm not a lawyer, so I'm not going to espouse as to what that looks like. I don't think that the DTSA case, the Defend Trade Secrets Act case against Deal, is very strong. And I think a lot of people came out immediately and said, oh my God, this is a perfect example of trade secret misappropriation. Maybe not, because if I look just at what we can see from the case filing itself, Rippling was not using reasonable measures to protect those assets.
That's
right?
what it comes down to. Yeah, exactly. And that's your point, is that, so look, in that framework we just talked about, where we can create, I believe 3 to 5x value by just doing the basics, right? Which is go into a company, understand what their business landscape, their markets landscape is, what their revenue model is, right? Start there and then work your way down and say, okay, these are your assets that are your crown jewels that you should be protecting as trade secrets versus patents or whatever. So we always are able to get to that part within 90 days really quickly, and even get as far as saying, okay, these are your identified trade secrets, and here's how you can protect them, right? Through licensing, through physical measures, through NDAs, whatever the case may be, right? That's just the table stakes of doing that. But to your point, what happens when someone walks out with that thing? Because inevitably it's not a foolproof system. And not having kind of until now through you guys not having any insurance around that, I think there's two things that are sort of perhaps been barriers in this regard, right? Like one is people just don't know. It's a lack of knowledge about trade secrets, and people don't think about that. Many like patents get a lot of patents and copyrights and trademarks are, the trade secrets are sort of like a stepchild of the IP world, I believe, even though they have a lot of value. So there's a
Yep.
bit of a knowledge gap. And the second thing I think has to do with just human behavior. I think we as humans don't want to prepare for things that we don't want to have happen for us, right? It's a good analogy of mine. A friend of mine who's a self-defense coach, right? And he described himself as a life insurance extension salesperson, right? That's what he calls himself. He's like, people don't say, "Oh, I always wanted to learn self-defense," and they're like, "No, you didn't. You didn't want to learn about self. You always wanted to not ever think about being in a situation that would make you want to
Where you
defend
needed to
yourself."
use, yeah.
So people just don't ever think about these things, and I think, in a way, it's good that this is getting a lot of press and media coverage, because I think this will become top of mind and center sooner rather than later, in my opinion.
Yeah, and one of the things that I think really needs to shift, and this is because I spent 20 years doing cyber insurance before I started my own company. I saw that market develop literally from its most nascent stage. I was involved in writing a lot of new policy wording and trying to convince people that they needed cyber insurance before it really became table stakes, and a lot of that was driven by regulatory requirements to notify people if personally identifiable information was compromised. But frankly, until somebody held a gun to the heads of a lot of senior leadership within these organizations, especially publicly traded ones, well, I guess that's not fair, but people don't want to spend money on prevention, right? It just doesn't sell. They want to spend money on things that are going to make the company money. And so there was an impetus for that, in that the public outcry over disclosures that were happening over and over again became really loud. Now, there is actually an SEC requirement for public companies to identify and disclose in their 10Ks what they're doing to mitigate risk to any asset that, if compromised, could reasonably cause a material impact to the company or to earnings, which includes, absolutely bar none, crown jewel trade secrets. They are in scope. But a lot of companies and their leadership seem unaware of that. I don't know if it's because there's so many silos within the brokers and the law firms that are advising these companies that the privacy and the cyber people don't think of trade secrets as insurable assets. That's just not what they're focused on. And the SEC people aren't talking. I don't know exactly why it is, but it seems to be missing in the discussion. So we're trying to raise that. The second thing is, if there is a compromise of that material asset, you have to be able to notify, you're required to notify via an 8K within 4 days of discovering that a material asset was compromised. And if you don't know what the asset was, and if you don't have a way to track when it goes missing, how in the world are you going to comply with that requirement to file an 8K? So I do think it's changing. What happens to the SEC under the current administration, I have no idea. And maybe people's are focused on other things, but I do think that the environment is ripe, and people should be very concerned about this. If you're an investor investing in a company because of this really cool green energy technology or water technology or whatever it is, and the thing goes missing, what did you invest? I mean, your investment is no longer protected. So it's got to be, table stakes for organizations to have to notify people and to really understand this risk.
I think you're hitting an interesting point, because it just reminds me of this story about Google. Like, when they found out they were being hacked, they went to the other companies down the street, the other big tech giants, right? And they were like, "Don't ask, don't tell. Like, we've known about this, but they just didn't want to come in because it creates work. I guess it's
it hits their it damages their reputation is really what they're worried about.
Right.
But if directors and officers of these public boards, their whole responsibility is they have a fiduciary responsibility to oversee the company and manage their most significant risks. And if you don't know what your trade secrets are and you're not protecting them, therefore, adequately, you can't possibly be protecting them using reasonable measures if you haven't identified them, because you can't tell your IT and other people, legal and HR, that are involved in putting those wrappers of protection around those assets. If you can't tell them what they are, then how are they supposed to treat them differently?
Right.
So it all
So,
starts with identification.
so that's actually a great point. I wanted to ask you about this because like I said, I think when we work with our clients, we get them to a point of where they can create a trademark registry. So like now they know, here's our, like, price lists or customer names or, whatever the case may be. So from then on, if they were to approach Crown Jewel, like how would you go about the process of insuring these assets, and what are the types of things that you guys do pre-post insurance, like from that point? Can you just like walk me through that part?
Yes, thank you for asking. So we developed something that we call trade secret asset risk management, a process that really dovetails and looks very similar to any other enterprise risk management process, except for that it's very focused on trade secrets. And the whole purpose of it is well, originally it was to get Lloyd's of London, comfortable that we could adequately underwrite this risk so that it's insurable, because the market hadn't figured out a way to do this until we came along. So we developed this whole process. But now it's turned into something that we can actually do on a consulting basis, because so many people need this part of it, which is the first thing we do is help the company identify the assets or harvest the assets that could be trade secrets. We have a couple of different partners that can do that. We have some questionnaires ourselves. It kind of depends on what the client wants. But there are technology tools that you can use. We can go into more detail about that. But essentially, developing a registry is absolutely critical of the assets that qualify as trade secrets. There's something called the 6-factor litmus test that determines whether or not something really is a trade secret or not. We apply that to each asset to help the client ascertain, does this have value? Did we uniquely create it? Do just few enough people know about it? Do we have proper protections around it? Once we've identified those assets, then we put a value on them. Ideally, that valuation can range anywhere from just give us your accounting information behind the R&D tax credits that your company took last year, because the first half, I'll call it, or the first piece of valuation of any trade secret asset is how much money did you spend to get where you are so far. So if you qualified for tax credit purposes around a specific innovation that's in your R&D pipeline, automatically that will suit for our purposes. However, there will be a lot of assets outside of R&D, like logistics and supply chain functions and strategic business processes and your M&A strategy and things like that, that don't necessarily bode well for that piece of it, because you didn't really spend a lot of money per se creating those. That's a different story, but at least within R&D, we can look at that. The
Yeah.
second component of it, which is the future value, which is why you're investing in this company in the first place, and why as a founder or innovator, you're spending all this time and energy, is because if you want to spend $5 million to make $100 million, right? That $100 million is much harder to land on. But we go with, a couple of different valuation firms to help us figure out what that number is. Suffice it to say that GAAP accounting does not properly account for that valuation at all. These are still off balance sheet items, and they're not even accounted for until you sell your company to another and there's goodwill. So we're working with a couple of valuation partners on a way to help us ascertain fair market value, quote unquote, of these assets using questionnaires and actuarial data around certain things that are trade secrets to us. But they will be revealed as much as we need to reveal them when we're talking individually to a client. We land on a value. Then we look at the individual assets to see how well they're protected, how well the company overall is protecting those assets. And once we're comfortable that they meet all of our criteria in terms of onboarding, exiting, non-disclosures, and non-competes to the extent that they're allowable under law, and all the technology things, like again in the Rippling case, they were used, this guy who was not even in sales and marketing, he accessed all the sales and marketing, quote unquote, trade secrets using the Slack channel, uploaded it to, I believe, his personal device, or downloaded, and was able to email that to their largest competitor. he should not have been able to do any of that from a
Right.
technology standpoint. And so we would not have underwritten that account. We would have immediately flagged that they don't have reasonable measures in place and that those assets would not have qualified as trade secrets for us, if that helps.
It does. It's interesting. So is this like the equivalent of like a pre-existing condition in healthcare? It's a bad analogy, but basically, if you haven't protected the assets to date, um, like would you actually go as far as figuring out if they've been compromised, or would somebody be able to say, look, if you want to protect them as assets, you can do these things and still make them protectable? Or is it like once the genie's out of the bottle, it's gone? Meaning, let's say I want to protect my customer list, right? So nobody has stolen it yet, but it's been sitting out in the open for a while. Is that protectable or not?
So what we would do if there's no known compromise, like it hasn't gone missing so far, is we would require that you do take certain measures to now lock it down and make sure that only people who need to know have access to it, that it's password, protected and encrypted and all that yada blah, that people who do have access know it's a trade secret. But we would still likely require that those policies and procedures be in place for a certain amount of time before we would implement the policy. And even then, we would put what we call a prior and pending date or a retroactive date on the policy that says that if something occurred prior to the inception of the policy, then it's not covered, which is very common in loss discovered or claims made insurance, because you don't want to cover something that's already on fire.
Yeah.
But the point is that trade secrets change by their very nature. The characteristics of the trade secret, what comprises the trade secret, so that even if you've really screwed up until right now, you can really change what that protection looks like in pretty short order and get yourself to the point where those assets are insurable, because the value or the characteristic of that asset is changing as well, if that makes sense. So even if we couldn't cover what your algorithm or the output of your Gen AI looked like 6 months ago, 6 months from now, it'll look very different. And we can pick up that exposure, if that makes sense.
It does. It's so funny. Like, talk about the best kind of insurance, right? Like, is that, let's say you have this trade secret. I mean, if you think about that Jeffrey Moore is like, the curve of innovation, right? Like you have this curve of like early adopters, majority, and then you get into this phase where like you have the business and it's generating a bunch of cash flow. I come across so many companies that have been in this phase of not innovating for a while because they've just been they found a product, there was a unique value proposition, they've just been like milking it, but they're literally one Gen AI feature away from being completely obliterated, right? Like the technology curve is moving so fast that if you're not innovating fast enough, no amount of insurance or no amount of thing is not going to protect you, right? Because in a way you want to insure what you have, but at the same time keep innovating so that like if and when it gets stolen, you have something to fall back on, right? Like one of the cases I talked about in the article was DuPont and Velcro. I think it was Velcro, one of the materials they came up with. It got stolen, right? And they won the judgment. The trade secret was like $920 million judgment. But once the genie was out of the bottle, that type of material was out in the market and they were being undercut. But the only reason they were able to survive that theft was because they were DuPont and they had a ton of other innovation and they had the financial backing to make that work. So a lot of small companies that are just coming up that are that I think are like in a very narrow sector and they're innovative, it's imperative you protect that, but keep innovating and start to think about the next big thing because the technology curve is moving so fast that you can't just sit on your laurels for a long time.
Yeah, absolutely. Well, and one of the other features of the insurance, not only what we do is we actually, as I said, we cover the fair market value of that asset against misappropriation, but the way that it works fundamentally is the coverage A, or the first part of the policy, is more like a cyber breach response policy, because that's where I live and that's how I came up with this idea in the first place. These are just assets that are not covered under a cyber policy. So that's how I fundamentally started. But then I expanded the coverage to pick up other types of perils, or bad actors that could take your assets, including former employees. Long story short, the way that the coverage A works is that you pick up the phone and call a trade secret lawyer who then involves a forensics team rather than calling a privacy attorney. and they will walk you through what you need to do to sort of prevent and mitigate that asset from being used improperly by a third party, including but not limited to seeking injunctive relief and all of those kinds of things, contractual, alleging contractual violations of non-competes and non-disclosure. So there are a lot of initial shots across the bow that we can employ if we get involved quickly enough and early enough, using our expertise of people who do nothing but basically trade secret litigation, to try to stop or prevent the bleeding so that there is actually no impairment to the asset, meaning no further damage. And damage in trade secret law means unjust enrichment of the third party or loss of clients. And if we're successful, then we only pay under insuring agreement A, because the client wins, they get their asset back, nobody can ever use it. Yay, everyone's happy.
Yeah.
Otherwise, then it converts to insuring agreement B, and we pay the fair market value of the asset. The reason why this is so interesting and has been interesting to the market, or one of the reasons, is because we will have done so much due diligence at the beginning and set the client up to win in litigation based on all the due diligence that we do. Then we've now done a forensic investigation around the source and scope of what happened for this particular claims event. If we then have to subrogate, then we've got all our ducks in a row already, and we don't have to spend 2 years and $4 million on discovery going backwards trying to figure out if there even was a trade secret and who had access to it and what's our argument that this was a trade secret and all the things that happened today in litigation. And if we win and we can prove that the third party egregiously took the trade secrets, as it looks like in the case of Deal, let's just assume that they were trade secrets. We already know that we don't think they all necessarily were. But in this case of Deal, then you're much more likely to succeed in getting treble damages as either part of the settlement or judgment, because egregiousness in trade secret law is meant to be, a punishable act. So
Yeah.
if we paid $10 million, the fair market value of the asset, we get 30, we pay ourselves back the $10 million, and then there's $20 million left over. We take a finder's fee, meaning the lawyers who helped us win and everybody collectively and then the rest of the money goes right back to the insured. So they actually get to participate on the upside. So we're not carving them out of the opportunity to win the bigger damages awards just because they have insurance. That, I think, has been a big misconception.
I think that's a key point, right? Because it's about optionality, right? You're giving these companies options in the case of an event like a trade secret theft, because now they have the option to say, okay, I could get it back. I could get it back with some money on top of it, so I can live to fight another day and innovate on a different area, even if this one is out of the bag. So I think the value of the insurance policy is pretty clear, in my opinion. The challenge may be that, is there any other kind of monetary benefit from the policy? So how if I have a life insurance policy, I can go out and then get perhaps a loan against it for my business. Is there any other kind of monetary benefit of having this policy in place besides the subrogation upside?
Well, we are looking at potential opportunities to take accounts where they've been clean for a couple of years, no losses for a couple of years, and this makes a lot of assumptions, but giving them either a discount back on the following year, or ideally taking some portion of that premium and allocating that towards grants that could be given to organizations that are innovating in a particular space that you could choose from, that are environmental related or human health, clean water, whatever the case may be. We haven't officially formalized that, but that is something that I think is really important. The other really big benefit to this, I think, is just having these assets valued by a third party and validated by a third party that they are in fact trade secrets. That's one thing that we're doing that is huge that I think most people don't recognize, is that when you lose a trade secret today, your only opportunity to prove that it's a trade secret is by litigating against the other party. And then you bring everything that you have to bear. So it's a litigation right, quote unquote. We're telling you as an insured, we and you both agree that these 6 assets are trade secrets. So we're taking that whole argument off the table, number one. And number two, and we're agreeing right now that the floor value of that asset is what we scheduled on the policy wording.
Right.
And so there's really only an upside from there, because we would certainly argue in subrogation that it impacted our stock price and we lost other customers as a result, and whatever else the other arguments we could make, et cetera, damaged our reputation, which you can't foresee when you're putting a value on it on the front end.
Yeah. And to your point, once you have those assets identified and there's a value attached to them, then I could totally foresee companies going to banks and lenders and saying, hey, give us some loans against us. We have a $5 million asset on the books now, like in many ways.
And it's insured, by the way, against the only peril that can devalue a trade secret, which is misappropriation. It's literally the only hazard. It's like, again, having insurance on the coast. You have to have wind and storm surge insurance before you can get a mortgage on a building on the coast. This is the same exact thing.
Yeah. So Mary, now this is a critical question. It's a tough one. So how we talk about drinking your own champagne or eating your own dog food, depending.
I have never done that in my life. I don't know what you're talking about.
So you mentioned you guys have trade secrets. So then how do you insure your trade secrets?
Right now, they are self-insured. We are mitigating that exposure the way that we need to mitigate it. But
I'm coming for them. We've already talked about this. I'm coming for them. You know this, right?
Well, you better not.
People. Yeah, exactly.
I know where you live and I know people. Yes, exactly. So, yeah, I think we will insure them at some point. Right now we are self-insuring them and we are mitigating because we're a startup. So, and I think, but that's a good point. By the way, startups, generally speaking, don't qualify for the insurance, just so you know. It's a London thing. But we need to see $12 million in revenue, essentially, and then we can start writing the insurance. That does not mean, however, that startups should not take advantage of the risk management offerings that we have, the consulting, which is, by the way, very inexpensive considering what you get. Because often, if you wait until you've got 100 employees to implement risk management around all of these innovation assets, it's too late for many of them. And you're going to have to wait another 6 months or a year before those have evolved enough that we are comfortable underwriting them, if that makes sense.
It does. And is it 12 million? It doesn't matter recurring. Is it top line revenue, 12 million?
Correct.
And does that have
and or funding?
Got it.
Yeah.
12 million in funding or revenue?
Yes, either.
Okay. It's funny because if you look at some of these Gen AI companies that are coming up, getting to 12 million doesn't take very long. Like there's a company I just did a post on this the other day, called lovable.dev. Their per user subscription is $20 per user per month. And they were started 2 months ago by 15 people. And they're doing 10 million in ARR in 2 months, if you can believe that.
Wow.
So that's what I mean. Like when you say startups, like I think the new age startups are very different than the companies perhaps you and I work for, and they'll probably get to that threshold faster rather than later. Which brings me to an actually interesting thing that I get asked about a lot, and I wanted to run it by you, which is like, what are the trade secret? Are there any nuances around trade secrets for Gen AI companies, right? Can they be thinking of I'm sure the data I'm guessing could be qualified as a trade secret that you use to train the models. What about the output?
If you own it.
If you own
That's
it,
a huge question mark. If they're scraping other people's data, they're violating copyright laws. And so that makes it a difficult discussion to have with them. We would have to peel back the onion on how and where they're getting that data, but go ahead.
That's a good one. So the first party data versus third party data is an interesting, so that's one question. So what if I'm a data aggregator? So some of my data is my data, but I'm aggregating that with third party data. And now the combination could be maybe a trade secret.
Yeah.
But then the second part of it is the model that's now trained on the data. And then the third thing of it is the actual output of that data, right?
Yep.
So and what of those pieces could be a trade secret?
So those are great questions. I would say that generally the quick and dirty answer is as long as you took data that was, it could be publicly available data that you use in some different and useful way to create an algorithm or a rating model or whatever it is that you're doing, as long as the use of that data is unique to you, then it can still be a trade secret, right? So that's data that's going in to train a model. If the code, that you're writing to train the model is your code, then clearly that's a trade secret. The output is where it gets really interesting, because there's a lot of case law right now, not a lot, but early case law is suggesting that output of generative AI isn't created by a human and therefore cannot be copyrighted or patented, which means the only way to protect the output of Gen AI is via trade secret protection. The concern that we have is if you use an open AI model like ChatGPT, as opposed to a closed model that's only available in training on data within your organization, for example, have you disclosed your trade secret by putting in potentially significant portions of trade secret information into the model to give you the output? So it sort of gets back to closed model with only your trade secret data, or that you aggregated using a combination of data, but still you have the unique input into the system. As long as you're not destroying the trade secret credibility by using a system that's open, then we could still potentially insure it. Does that make sense?
It does. It reminds me of an analogy. So back in the day, and we've been having a lot of these conversations with our clients around this, right? So back in the day, when you were filing patents on software code, you actually had to submit code that actually did the thing that you're trying to patent. Like you had to submit the code, and then that requirement went away, and then people just had to submit flow charts, right? So as long as you had the flow chart and the design of the system, you could patent the system in software. I wonder at some point that because of where Gen AI today, that you don't have to even write the code anymore, and you can just ask the question and it gives you the answer. I wonder, because I've seen patents being filed, I don't know if they're being granted, but there's certainly the use of Gen AI to generate prompts that then generate something, right? So I wonder at some point, legally, there'll be case law around this, which will be, the ability to generate prompts for using Gen AI to then do code, is that patentable or trade secret protected? And the second thing is, are the prompts themselves, because some of these prompts can be pretty long, right? And depending on what you're doing. And I wonder if those prompts by themselves are going to be patentable or trade secret protected. That would be an interesting.
It will be a really interesting area to watch, because at some point, does everybody own everything? I mean, traditionally, trade secret law has been a lot about ownership. That in order to prove misappropriation, you have to show that a trade secret exists, that you own it, that people who had access to it had noticed that it was a trade secret, and that they had access. Those are the EONA proofs. But the O is O, and that's a big issue. Did you own it in the first place? So we would have to have a lot of conversations around that once particular assets had been identified as to, okay, did you really, company, create this asset yourself? And what data did you use to do it?
Yeah.
So I think with that, Ayaz, we're over. I could talk to you for hours. We certainly can do other podcasts on different topics, but is there anything else that you wanted to say about valuation and closing and the importance of insurance before we get off of this particular one?
No, I think, like you said, there's probably like 15 different topics that we discussed about that we can probably do a deep dive on. But I think it's a very important conversation. I think it's a very timely conversation we had, and I really appreciate you taking the time to speak with me myself, because I think this question has been coming up with my clients that, okay, now we've created this registry with your help. What do we do next? So I look forward to engaging with you and our clients for sure, and hopefully help you guys prosper as much as you should.
Absolutely. Yeah, because again, we always need help, and help, to get our clients in a position where they can better articulate the value of their IP, and certainly strategize around when they should patent something, versus leave something a trade secret and other types of things that are beyond the scope of what we are prepared to do as non-lawyers. So,
Definitely.
all right, Ayaz, so good to see you. Thank you so much, and we will be in touch.
Thanks, Mary. Appreciate it.
Thank you. Oh, wait, did you want to give your contact information? How can people find you?
Yeah, just find me on LinkedIn, or you can do it at prestizaequity.com.
Okay, sounds good. Thanks,
Perfect.
Ayaz.
Thanks. Take care.